Hello and welcome to One and All Present. My name is Lakshaya and I'm an intern at LEXIS and Co. The topic for the day is Banning of Unregulated Deposit Schemes Bill 2019. Mr. Nirmala Sitharaman, Minister of Finance, tabled the banning of unregulated deposit schemes in 2019 in the Lok Sabha on July 19, 2019. The bill establishes the framework to prohibit unregulated deposit schemes and protect depositors' interests. The Reserve Bank of India Act 1934 and Securities Exchange Board of India Act 1992 and Multi-State Cooperative Societies Act 2002 are all being amended. A deposit, according to the bill, is money received in the form of an advance or loan or any other form with the promise of being returned with or without the interest. Such a deposit may be repaid in cash or as service, and the time of the return could be defined or not. Furthermore, the bill specifies specific amounts that will not be included in the definition of deposit, such as amounts received in the form of loans from relatives and capital contributions made by partners in a partnership firm. The 9 authorities are currently in charge of overseeing the regulating various deposit-taking systems. The Reserve Bank of India and Securities Exchange Board of India and the Ministry of Corporate Affairs and state and union territory governments are among those involved. For example, the Reserve Bank of India controls deposits taken by non-bank financial institutions. The Security Exchange Board of India governs mutual funds, and the state and union territory governs regulated funds. All deposit-taking schemes must be registered with the appropriate regulatory body. The bill prohibits the use of unregulated deposit schemes. If a deposit-taking program is used for a commercial purpose and not in the register with the number of regulated schemes, the interest can be improved on the existing regulated schemes. Individual groups of individuals or others seek to fit for solicit or receive deposits are being defined as deposit takers in the bill. Deposit takers do not include banks or other companies incorporated under any other law. The bill calls for appointment of competent authority to be made up by one or more government officials who are not below the position of secretary of state or central government. Information about offences committed under the bill will be reported to the competent authority by police personnel. In addition, with or without a warrant, police officers not below the rank of officer in charge of a police station may enter, search and confiscate any property suspected to be associated with an offence under the bill. The competent authority has the authority to first attach the deposit taker's property and all deposits received on a temporary basis, call and interview a person it deems essential for the purpose of acquiring evidence, and third, order the production of records and evidence. The competent authority will have authority comparable to that of civil court. The bill calls for establishment of one or more designated courts in designated locations. A judge with the state of district and sessions judge or an extra district and sessions judge shall preside over this court. The competent authority will approach the designated court after provisional attachment of the deposits taken assets. I make the provisional make provisional attachment absolute and seek permission to sell the assets. The competent authority will have 30 days to seek the court, extendable to 60 days. It will also open a bank account to release the disbursed funds to depositors in accordance with the designated court's orders. The designated court will have the authority to first, make the provisional attachment permanent. Second, vary or cancel the provisional attachment. Third, finalize the list of deposits in their respective dues. Fourth, order the competent authority to sell the property equitably, distribute the proceeds to the depositors. And after being contracted with the competent authority, the court will try to conclude the process within 180 days. The bill calls for the federal government to appoint a body to build an online central database of depositors taker information. All deposit takers will be compelled to report their operations to the database authority. The competent authority will expect to provide authority with all information on unregulated deposits. The bill establishes 3 sorts of offences as well as punishments that go along with it. These offences include number 1, running, advertising, promoting, operating or taking money for unregulated deposit schemes. Second, fraudulently defaulting on regulated deposit schemes. Third, misleading depositors into investing in unregulated deposit schemes by deliberately fabricating facts. Accepting unregulated deposits, for example, will result in sentence of 2 to 7 years in prison and fine of 3 to 10 lakh rupees. Failure to repay unregulated deposits will result in prison sentences ranging from 3 to 10 years, as well as fine from 5 lakh to twice the amount collected from depositors. Repeat offenders will face a sentence ranging from 5 to 10 years in prison, as well as a fine ranging from 10 lakh to rupees 5 crores in rupees. That was all. Have a great day.